Former Solicitor General of India, Harish Salve, joins us now. Thank you, Mr. Salve, for your time. How do you look at the Supreme Court's judgment today? If bail is the rule and jail is the exception, how does the Supreme Court justify years of incarceration under UAPA when the trial hasn't even begun?
You confuse so many different idioms. But not your fault, you're not a lawyer. Jail is the exception, bail is the rule in normal law. We have statutory exceptions to this principle. In the old IPC, section 302, jail was the rule, bail was the exception, because the accused had to establish that there was no case. It was not for the prosecution to establish that the accused had to be kept inside. So these are good general catchphrases, but they don't set out the law accurately. So this is what happens. The UAPA has provisions, the drug law, the anti-drug law has provisions like that. There are a number of statutes in which bail is not the rule. Bail is the exception, jail is the rule, if one may put it in a catchphrase. So the burden is very high, and accused has to show there is no case made. That is a high bar. There is an entirely independent ground that if a trial is being delayed, the bail should normally be granted.
Okay.
The purpose of incarceration, pre-trial incarceration, partly is preventive. If there is a fear or concern that if bail is granted, there will be witness tampering, there will be interference with the course, or the events may repeat themselves. And that is where the balancing comes in. Now, undoubtedly, unconscionable delay in commencement or prosecution of a trial is a very strong ground, but it's quite another matter where 3 courts have now found concurrently that the delay was at the door of as much as of the accused. And many times accused are in no tearing hurry to get on with the trial for good reason. And these are what we call in the criminal court, these are forensic ploys. Many times you don't want to go on. You don't want to go on with framing the charges. You want to see what happens, etc., etc. So if those are the things which are in play and which have caused the delay, then this principle of prolonged incarceration doesn't apply. See, the state is under a duty to have quick, efficient trials. Forget this case. In any case, criminal trials should not be kept hanging because there is a mental price you pay for a criminal case pending against you. Yeah. So speedy justice is a rule under Article 21, but many times the accused, so if there is absence, if there is no judge present, if the judge has gone missing, if the prosecution is not showing up, those are cases of extended incarceration. Here where the fault on balance lies more on the, as much if not more on the accused as it does on the prosecution. Then that principle doesn't come into play. So that's why I said you mixed up 2 idioms.
Okay.
Bail, not jail is one.
Okay, so that was a good clarification. But Mr. Salve, in the last many years, we've seen that Supreme Court has often nudged the government to do away with the colonial sedition law, which some people are now saying is back in disguise in the form of the new criminal laws. Courts have been ruling out that even shouting certain slogans, I don't want to say those slogans now, is not an act against the country. So how does any speech attract UAPA to keep individuals in jail for a long time?
2 short answers. Context matters. Societal context matters. The time you see, there was a strong argument against death penalty. For abolition, there was a strong pro-abolition argument. With the advent of terrorism, that argument has fallen away.
Yes.
So you cannot view these things divorced from the context of the times. Secondly, I have only read the Supreme Court judgment cursorily. I have not analyzed it in great detail. I know nothing about this case before I read this judgment. The court has said that it is not just a speech. It is a course of conduct. The speeches were a part of the overall course of conduct. And the course of conduct was clearly within the meaning of the unlawful acts. So sedition is a side issue here. It's terrorism within the meaning of the unlawful act, and the Supreme Court has construed the phrase by any other means. So the whole discussion is very different. I'm surprised who's talking about sedition here.
Right. Sir, I know you've touched upon this. The 2020 Delhi riots have been the worst form of violence that the capital witnessed since 1984 anti-Sikh riots. In both these instances, in both these cases, we did see that police action came under a lot of scrutiny. But the larger criticism is that in the 2020 Delhi riots cases, there was an impression that accountability focused a lot on intent and speeches. What kind of lessons do you think the state, agencies and administration need to learn from this episode?
In 1984, was there any action? I'm not aware of any action. Prior to certain actions, the only time actually, first time where riots have been prosecuted was the Gujarat case.
Yeah.
Post-Gujarat riots. And of course, the narrative is nobody prosecuted in Gujarat, but the only time where prosecutions have been laid is, look at Bombay.
Yeah.
1992 riots, one of the worst, 93 January riots, one of the worst ever in the history of India. Are you aware of any prosecutions?
No.
I'm not. In fact, there was one prosecution where somebody was caught with a automatic rifle, and even that was withdrawn.
Yes.
So, when people give lectures on prosecution, etc., it's no use. Let's talk about this.
Yeah.
The FIR was registered in Jan 2020. I think the first charge sheet was filed pretty early by November 2020. So I think it was all fairly quick. And it was, the court has said it's a complex investigation. See, these investigations which are trying to unravel, look at what's going on in our neighborhood. Look what's going on in Bangladesh. Look at what happened a while ago in Burma. And look at what happened in Sri Lanka. Look at what happened in Nepal. There are people who want that playbook to play in India. Now, you may strongly feel that a particular government should go. You may strongly feel the system of order is wrong, etc. But laws are made to protect society. And if you cross those lines, you pay the price.
Right. Sir, just an offshoot from my earlier question, how fair can riot trials in India truly be? Because, I've seen both sides holding deeply polarized views. So in that case, how can courts balance the demand of security? It's just not a demand, it's a responsibility, duty of the state with principles of justice.
Fortunately for us, the court doesn't have to deal with the kind of debates you see on TV channels. The court is concerned with evidence. The law is clear. The interpretation has been given by any other purpose. Supreme Court has said that's an unlawful activity. They have said prima facie, if all this is correct, then this would be unlawful activity. And if the evidence is there, the conviction happens. Thereafter, you can continue having debates on TV whether India has fair laws or unfair laws.
Right.
But today one can debate anything. There are people who justify going into another country, grabbing their president, putting him in handcuffs and bringing him in. All sorts of things are going on. So we don't want to, those are academic debates we can have on different fora, on TV and in speeches and saying India has become illiberal, etc., etc. I want my India to be safe. I want my India not to suffer. We are an island of democracy today. We have failed states all around us. We don't want to go down that road.
Absolutely. One of my last questions to you, Mr. Salve, a few days ago we also saw the new mayor of New York, Zoran Mamdani, writing to Umar Khalid saying that he remembers him. There were also other congressmen who talked about a speedy trial in this case. Do these international incidents, developments also have any impact on Indian judicial processes?
So I don't think so. I think Mr. Mamdani has his plate quite full trying to fix what's gone wrong with minorities in his own speeches where minorities are treated appallingly in his country, right? I think they should all focus on that.
Okay. And one last
we have
question.
more. Our courts and our citizenry and our media, all of us are strong enough to keep India's democracy ticking. We don't need Americans and their system of extradition, their system of trial, their system of police atrocities. I mean, we can also go on and on about them, but why? You be happy in your country, let me be happy in mine.
Right. Last question,
and
sir.
Mr. Mamdani, best of luck dealing with New York's discrimination.
Okay. So you think no impact of that, but even on public pressure?
Irrelevant. They are completely irrelevant, and I think they should be treated with the contempt they deserve.
Okay. And so the timeline of 1 year that has been set for the accused to appeal, is that usual?
Not appeal. It happened many times. If you are sitting in a court, this as a practicing lawyer, sitting in a court. So many times the court says too early, come back after 6 months, come back. It's not time.
Yeah.
It is, you're giving one more year. If in that time also, now with this crack of the whip by the Supreme Court saying stop procrastination, do not allow the accused to play these games, trial court, please crack on. It's a message to the trial court that within 1 year's time, you should have crossed at least all the protected witnesses. Then the court will see what is the evidence which has come on record, how far has it got. If it is satisfied that it has got to a place and there's even stronger evidence, it may not grant him bail. If it feels that it is now safe to grant, see, this is not punitive incarceration. So if you feel now there's no damage he can do, even if he's let out, he'll be let out.
Right. Thank you, Mr. Salve, for your time and for speaking to NDTV. Thank you, sir.